topic chosen is becoming an advocate. You have to remember that once you become an advocate, you become a student of law for life. Whether you sit in a law firm or you work in an office for an advocate, or even if when you begin to practice before a court, even when ultimately in course of time, you, God willing, also become a judge. Because once a student of law, always a student of law. This is because no one, howsoever senior or advanced in knowledge or in age, can ever say, I know the law. The law is as vast and unfathomable as the starry heavens in the sky that you see on a clear night. Please always remember that. And remember also that becoming an advocate is both a responsibility and also a badge of fame. But first things first, the first thing you must remember on becoming an advocate is that English is not a foreign language. Since 1950, it has become an Indian language. It is one of the two national languages of India. So the first important thing you do on becoming an advocate is to please improve your knowledge of and a proficiency in the English language. This you must do by reading and absorbing the great pieces of writing in English literature. This is not in order to make you anglicized, far from it. It is to give you an opportunity to establish yourself and be successful in the legal profession. Because the law in India is and will remain English in origin. All the great concepts in the Constitution are Anglo-Saxon, like liberty, equality, rule of law. Justice Felix Frankfurter is a name that is or should be familiar to you all, because he was the judge whom India's constitutional advisor B.N. Rao had consulted when he drafted the Constitution of India. But he is also famous for another reason, and you must know it. In 1954, a 12-year-old American student living in Alexandria, Virginia, wrote a letter to the judge and said he was interested in going into law as a career, and he asked for advice. Frankfurter's now famous advice to a young man interested in going into law is in the public domain for all to read. And his advice given in 1954 is as follows. The best way to prepare for the law is to come to the study of the law as a well-read person. Thus alone can one acquire the capacity to use the English language on paper and in speech, and with the habits of clear thinking, which only a truly liberal education can give. So, stock your mind with the deposit of much good reading. Widen and deepen your feelings by experiencing as much as possible the wonderful mysteries of the universe, and forget all about your future career. This was Frankfurter's frank advice to a young American. It remains valid today for India. I heartily endorse the same and pass it on to you. You will find Frankfurter's advice to a law student recorded in a book titled The World of Law. The book is in 2 volumes. The first volume, the title is The Law in Literature. The second volume has the title The Law as Literature. In these 2 volumes, you will find extracts of essays, opinions, stories, records of famous trials, speeches, all compiled by a distinguished English constitutional lawyer, Mr. Ephraim London. That's his name. These 2 volumes contain a mine of very useful and excellent writing in English. If you find that the book is unavailable, it might be since it was published nearly 60 odd years ago, feel free to write to me and I'll be glad to send you some extracts in depth, which you must read and digest so that you come up to scratch in your profession. You will then be Frankfurter trained in the law. So remember, the first rule on becoming an advocate in India is to be proficient in English by stocking your mind with good reading. Reading about law as literature and reading about the law in literature. Next, keep yourself informed. Be up to date with Indian case law, that is, decisions of the Supreme Court and of High Courts, particularly your own High Court. This is essential for the profession you have chosen. In this way, you will be useful to your senior in the profession and later to yourself as well when you appear in court. Even when you or your senior are not briefed in a case, you can be useful to someone unknown to you arguing a case in court. You can be of help to him because when you are of help to him, by giving him some very recent judgment relevant to his case, he will remember your good deed and will surely be of help to you. Sir Jamsetji Kanga, the doyen of the Bombay Bar, in whose chamber I had the privilege to read, had little work in the first few years of practice. In those days, long before the Constitution of India 1950, there was far less work for juniors than there is today. He told us that he spent his time reading all the then current decisions of the Privy Council and of Indian High Courts. But during the day, he would sit in court, seeing and listening, and so learning how to argue, and particularly how not to argue, merely by watching other lawyers presenting their cases in court. This is the best way in your becoming a successful advocate. Also remember that Parkinson's law applies in the profession of law more than in any other. The less work there is, the less inclination there is to put your mind to it. So the less will be your experience. The less will clients seek you out as advocate, and so you will have less work, all in a downward spiral. And the more you are engaged in work, the better will be your application of mind. The sharper will be your intellect, and then everything will be in an upward spiral, only the sky being the limit. But work here means being occupied, not necessarily paid work. The worst enemy of hard work is a fixed monetary reward. There is no incentive when your senior keeps paying you a stipend. Of course, if it is necessary for you to survive, take the stipend, but don't depend on it forever, because you are then in the position of an employee or an office clerk. You will soon begin to work less and less, and only in office hours, and then in company of other lawyers, you will begin to complain how poorly you are paid. There are no office hours for a practicing advocate. You have to be mentally engaged day and night. Remember that when you assist another person to argue, you must be of real use to it. This you can do only if you have looked up or studied the facts, made short notes, looked up the entire law pertaining to the case. Not only relevant law, but also law having some remote connection with the facts. This is because, although in a court of law, only relevant facts are to be stated, there is one very important but least known section of the Indian Evidence Act, which is section 165, which reads as follows. The judge, in order to discover or to obtain proper proof of relevant facts, may ask any question he pleases, in any form, at any time, about any fact, relevant or irrelevant, and neither the parties nor their advocates shall be entitled to make any objection to such question. It's a very important section. This is because a judge at a trial or in a proceeding is expected to explore all avenues open to him or her in order to discover the truth. So in an Indian court of law, as an advocate, you must be prepared not only the facts of your case, but all possible permutations and combinations that can be imagined. So when you have a brief, you must always go beyond it and be ready with answers to the judge's questions, relevant or irrelevant. And you can be sure that a judge will ask many irrelevant questions, and you have to patiently and politely answer them. Next, after you have read your brief and reread it, take time to reflect. Think on it. It helps greatly. This is the advice I was given by C.K. Jaftari, who was for many years Advocate General of Bombay, then India's Solicitor General, first Solicitor General, 1950 to 63. And after Motilal Sethalwat retired in 63, he became India's second Attorney General. In his time, C.K. Daftari was the greatest exponent of the art of advocacy in India. Over time and in your progress in the profession, you will be involved in several cases. Remember that a good lawyer keeps his important pending cases always in mind. They must travel with you, whether at lunch parties or at dinner parties or when you are out for a walk, especially when you are out for a walk. You must give your subconscious mind an opportunity to soak in a case. And when you do that, you will find quite often to your advantage that problems get almost automatically solved. Solutions emerge as if providential. Next, as a lawyer, it is your duty to bring to the attention of the court a case already decided on the point advance. You may then distinguish it, but cite it you must. And never cite an overruled case. It is unethical. So Jamsetji Kanga used to tell us that in the old days, there used to be a solicitor in Bombay who was a tricky fellow because he kept a separate book containing all overruled cases. And when the going was rough in court for his client, he, the solicitor, handed over to his advocate an authority which he knew had been overruled. The advocate would cite it. The judge would get confused. The other side would get confounded, but not for long. Ultimately, it would be discovered that the case cited had been overruled. But the consequence for you will be disastrous. The judge would then look you at the face. Always remember your face, and as a person who misled the court. Counsel citing an overruled case is invariably blackballed by the judge. The solicitor from Bombay is not a person to be emulated. We only remember him as a person who did the wrong thing. Next, in court, it is always better to understate your case rather than to overstate. Never tell the judge you have a cast iron case, or that I never heard this argument before. When I used this phrase when I was 10 years old at the bar, I swore never to use it again. Because the judge smiled at me and said, "You are still at the beginning of your career, Mr. Nariman. In course of time, you will hear and learn many more things that you have never heard before." For me, it was a perfect squelch. Also, never say your lordship will bear with me. In my young days, when the judge in Bombay used to argue with me by questioning me in a case, I used to say quite frequently, "Your lordship will bear with me," just to put my point across. And the judges there did not seem to mind. But then in the Supreme Court, to which I shifted in 1972, Chief Justice A.N. Ray was horrified by this expression. When anyone said in response to an interjection from the bench, "Your lordship will bear with me," that would come the irritable answer, "Then what do you think we are doing up to now?" Never exaggerate in court about the facts of your case or the applicable law. Argue in low key. Low key is the answer. Avoid rhetoric and don't be too smart. And for God's sake, at this stage of your career, avoid being funny in court. You will be stigmatized as flipper. In fact, until you have established yourself in the profession for at least 30 to 40 years, do not indulge in what is known as pleasantries in court. You have to be serious-minded in court, especially in your formative years. And never trump the judge's jokes or make it appear you are more humorous than he or she is. And if you must tell a story, tell one against yourself, never in your favor. And particularly, remember to laugh heartily at jokes cracked by the judges from the bench, even the corny ones. But more seriously, never show irritability in court. Leave your anger and all the vitriol that goes with it outside the courtroom. Never take it into court. And if you are tempted to be angry, remember what the great Lord Eldon once said. Lord Eldon was a famous English judge who sat for 25 years as Lord Chancellor of England. Back in the year 1787, as plain Mr. John Scott, that was his name, he argued a case in the equity courts and he remembered it. 35 years later, the same case was cited to him when, as Lord Eldon, he was presiding in the Court of Chancery. And Eldon said he remembered the case. And this is what he said: "Very angry I was with the decision, but I have lived long enough to find out that one may be very angry and yet one may be very wrong." Words of pearly wisdom. Hopefully, you too will live long enough to find out for yourself that you may be on occasions very angry and yet very wrong. Justice Krishna Iyer, the great and noble Justice Krishna Iyer, used to delight quoting in his judgments the exhortation of Oliver Cromwell, Lord Protector of England from 1653 to 1658, when he used to tell his constituents, this is Cromwell, "I beseech you in the bowels of Christ, think it possible you may be mistaken. Think it possible you may be mistaken." As a practicing lawyer, you will also be very often mistaken. It is no discredit to admit that you were mistaken. Next, don't quarrel with your opponents or be nasty to them in court. Because if you have chosen the law as your profession, the major part of your life will be spent with colleagues at the bar. You have to rub shoulders with them, and a sense of camaraderie at the bar is essential for preservation of your continued sanity. Your compatriots will always speak well about you if you have not been mean or uncharitable to them in word or action. Because the old English adage holds, "Dog, don't eat dog." Never address a court below its station. Each judge must be addressed according to the manner in which his position entitles him. For instance, an administrative officer who presides at a hearing must be addressed as "Sir," magistrate as "Your Honor," a city court judge, a district court judge also "Your Honor," but a high court judge always "Your Lordship." Sometimes omission to observe this elementary rule can be disastrous. It was for my opponent in a case that I will recall. There used to be in my time a judge, Justice J.M. Shellert, who was first appointed a judge in the Bombay City Civil Court. That's the district court for Bombay. Then in the High Court, and finally in the Supreme Court. Now in the City Court, a judge is always addressed as "Your Honor." In the High Court, he must always be addressed as "My Lord." Shellert was sensitive about the change in the forms of address when he became a High Court judge. And as a High Court judge, he was allergic to being addressed as "Your Honor." And if any lawyer inadvertently addressed him as such, they would suffer by losing their case. It happened to me in my young days when I opposed another young lawyer. The opposing advocate is today a brilliant commentator on public affairs. He kept referring to Justice Shellert in the High Court as "Your Honor." And so brittle did the judge become that he ultimately delivered judgment in favor of my client. It was, of course, a wrong judgment. When the appeal came up for hearing before a bench of 2 judges in the appeal court in Bombay, the appellant was not called upon to argue. Appearing for the respondent, it was I who was immediately asked to defend the judgment. And of course, the judgment was reversed. But to his credit, you must know that Justice Shellert worked himself out of this blemish. And in the Supreme Court, to which he was finally elevated, he became a fine, seasoned judge. He also had a literary bent because he read a lot in his spare time and had written a good book on the life of Akbar the Great. I give you the example of Shellert only to indicate to you that some judges are more sensitive than others, some more apt to take umbrage or offense more than others. So when arguing, you have to be careful what you say. You must have your wits about you. In David Panick's book, David Panick is an English barrister who has written 2 excellent books. He is now Lord Panick. One is called Judges and the other is called Advocates. You must read both of them. In Panick's book on Judges, he mentions the somewhat farcical case of Sardar Tajendra Singh. Now, Sardar Tajendra Singh was an Indian, but born in England and brought up in England. But he had no respect for England, its civilization, or its courts. He therefore persistently refused to stand up while addressing the Cambridge County Court in support of his claim for money owed to him. The trial judge ruled that until Sardar Tajendra Singh gave an undertaking in writing that he would stand up and address the court, his case will not be heard. Now, Tajendra Singh was a funny fellow. He did not apologize. Instead, he went in appeal. At the start, 3 judges of the Court of Appeal, Sir John Donaldson, then Master of the Rolls, was presiding. He allowed Mr. Tajendra Singh to address them sitting down because, as the judges humorously put it, to avoid prejudging the fundamental issues raised by this case. A typical English understatement. But ultimately, they decided that the county court judge was entitled to the dignity of his office and to require Mr. Tajendra Singh to stand up. Next, don't criticize the judge before whom you have appeared. This is very important. Don't criticize the judge before whom you have appeared in the bar room or before clients. When you are in a calm or collected mood, reflect on what transpired in court. Ask yourself whether the judge may not have been right. Otherwise, consult a senior lawyer who is not opinionated and follow his advice. If you must say something about the conduct of a judge, say it in the Court of Appeal, in open court, never outside court. If not, hold your peace, remain silent. Francis Bacon, he was Attorney General in England in the 17th century, he was later Lord Chancellor, used to say that a much-speaking judge is an ill-tuned cymbal. A much-speaking lawyer is worse. He is like a broken drum. It sounds horrible when beaten. So talk less, reflect more. Next, learn to lose with dignity. Please remember, only one side in the case can win. The other side must lose. And you must always be conscious of the fact that the judge is compelled to decide either for one side or for the other. And don't jump to conclusions about the judge hearing your case. Many so-called speaking judges who interrupt a lawyer's argument in court will disclose their mind. At the start of the case, they will say something against your contention. Never assume that the judge is against you without hearing you. He often poses questions seemingly against your client's case only in order to get the best out of you, not because he has been sold to the case of the other side. Please remember that the entire edifice of our legal system, of which you are a privileged member, exists and can only survive on the basis of mutual good faith between bench and bar. Never give interviews or talk to the media about cases in which you yourself are appearing. It smacks of cheap publicity, and it is unfair to the judge who cannot retaliate. If the judgment in the case in which you have appeared needs to be criticized, such criticism will be more appreciated when it comes from disinterested quarters and not from you. Also, never complain about the inadequacy of the time set by the judge for your argument. You thereby expose your own incompetence of not being able to put in simple form the essence of your case. Believe me, there is nothing like the constraints of time to sharpen your mind. What will then emerge will be only the relevant and not the useless and the irrelevant. I have seen in federal courts in the United States, counsel being 5 or 10 minutes to complete an argument. And judges there have told me that after reading the papers and forming their one view, they have often changed after hearing the brief but persuasive arguments of counsel at the time of oral hearing. When time for argument is preset, and in my view, it always should be in all appellate courts, don't complain when the judges enforce it, because that is the discipline of the law. Many years ago, as president of the Bar Association of India, I had invited Professor Archibald Cox to give a series of lectures in Delhi, Bombay, and Madras. He had served as Solicitor General under President John Kennedy and was one of the most cited scholars of the 20th century. He told his audience about his experience of the time limit imposed by the Supreme Court of the United States when hearing cases. And he spoke about the landmark case which he had just then argued, Regents of the University of California versus Bakke, a case for establishing the principle of reverse discrimination. Cox was allotted 30 minutes of time. Then and now, this is the maximum time given for oral arguments in the US Supreme Court, however important the case may be. And there are 9 judges who closely question him. So there were these 9 judges questioning Mr. Cox, and he was attempting to answer their questions. In the US Supreme Court, an ominous bright light comes on when your time is up. Since the point he was making was extremely interesting, Cox, even after seeing the light come on, continued. The presiding judge, then Chief Justice Warren Burger, pulled him up. He said, "Mr. Cox, the light is on." But Cox went on for another 30 seconds. This time, the Chief Justice said in louder, more peremptory tones, "Mr. Cox, the light is on." And poor Cox had to sit down mid-sentence. That was his view, and that was what his advice was to all of us. Some years ago, I read an article written by an American advising young lawyers on how to argue in the appellate court. There were about 20 tips, 20 little points on how to argue. The last one was sit down. It was and has always remained for me the best piece of advice for a young practicing lawyer. Now, far too much advice. Something different now. As to how well prepared must a practicing lawyer be, let me relate to you a few stories of some of India's greatest lawyers of the 20th century. A.V. Vishwanath Sastry practiced in the Supreme Court of India from 1956 onwards till he died in 1966. He was a wizard, an advocate par excellence. When I was practicing in the High Court of Bombay from 1950 to April 1972, I had the good fortune to assist him as a junior in a few cases in the Supreme Court. But assisting Mr. Sastry in a case was superfluous, entirely unnecessary. He never needed to be assisted because he knew his facts. No one could teach him or even guide him on law because he knew his law and he knew all the decided cases. Whenever I was briefed to go to him in Delhi, I would mention what I thought were the relevant cases. He already knew them all. He never made you feel small. He never showed off. He would just shake his head and simply say, "Ah, yes, ah, yes, ah, yes," in his affable sing-song manner. But there is one incident I must tell you about, which is outstanding. Somewhere in the mid-1960s, in a case presided over by Chief Justice Gajendra Khatkar, he was a judge from Bombay who came to the Supreme Court. He was the 7th Chief Justice of India. Sitting with him was Justice R.S. Bachawat, another very bright judge from Calcutta. The great advocate Vishwanath Sastry, there is a portrait of his, not a very good likeness, but there is still a portrait that hangs in the Advocates' Lounge in the Supreme Court. Go and see it when you are in Delhi. The great advocate Vishwanath Sastry was arguing in his inimitable, soft but sure manner, when Justice Bachawat, a fine judge who also had the law on his fingertips, reminded Sastry that the proposition that Sastry had been then canvassing for was directly contrary to what the Privy Council had said in a case. And offhand, he mentioned the Privy Council judgment to Sastry and gave him the approximate reference. For a few moments, there was complete silence in court. After a couple of minutes, Vishwanath Sastry's sing-song replied, "Yes, my lord," he said. And that is the only decision of the Privy Council that has been adversely commented on in Halsbury's Laws of England in volume such and such. Magnificent. Now there are over 100 volumes of Halsbury's Laws of England, and he remembered which volume. This was too much for Chief Justice Gajendra Khatkar, who was a scholar judge. Gajendra Khatkar said, let us suspend the proceedings, send for the decision of the Privy Council, send for the volume of Halsbury mentioned by Mr. Sastry. The books were brought in, and sure enough, there was the judgment of Privy Council, as Bachawat had promptly, off the cuff, recollected. Equally sure, there was that passage in Halsbury's Laws of England, which had commented adversely on the opinion of the Privy Council, and Vishwanath Sastry, on the spur of the moment, had recollected. My dear fellow students of law, this is how well prepared a practicing lawyer must be. This is how well prepared a practicing lawyer must be. I cite to you another instance. When I was practicing in Bombay from 50 to 72, the great international trademark lawyer, Mr. Blanco White, had been invited by K.S. Shavaksha, himself an expert in Indian trademark law, to lead him in an important trademark case before the Chief Justice. Incidentally, Shavaksha was the son-in-law of India's great jurist Sir Dinshaw Mullah. During the day, Blanco White had appeared in the Chief Justice's court in Bombay. In the evening, at a reception given for him by K.S. Shavaksha, Blanco White, whilst chatting with us youngsters, told out about the accuracy of Halsbury's Laws of England in all its editions. He told us that he had been entrusted the task of writing the entire trademark section of the third edition, the Simmons edition of Halsbury's Laws of England. And after it was completed, he had submitted it to the Lord Chancellor, Lord Simmons, who was the general editor of the third edition of Halsbury. And mark you, Simmons was not a trademark lawyer. A couple of weeks later, Blanco White told us that he received a telephone call from the Lord Chancellor's office asking him to drop in. When he did, Lord Simmons pointed out to Blanco White that two short passages in his text were not supported by the cases that were cited. This is how carefully the general editor of Halsbury's Laws of England examined the text submitted to him. Blanco White later found that the Lord Chancellor was right and he was wrong, and he made the requisite correction. I, for one, am always envious of such fantastic scholarship. It is so rarely seen these days. A.K. Sen, Ashok Sen, a great advocate of his time, who never spoke ill of anyone nor even against his opponent. I had the privilege to appear with him in several cases, including the landmark constitutional case of Golaknath. Sen had a story to tell about another great advocate of his time, Bhulabhai Desai, of the INA trial fame, as to how important it is for an advocate to have an outstanding memory. You have to cultivate it, an outstanding memory. This story was narrated to him by B.P. Khaitan, one of the senior solicitors in Calcutta in the late 1940s. And the story went as follows. Khaitan's client had briefed Bhulabhai Desai in a very heavy testamentary suit, that is concerning a will, to come up in the Bombay High Court, and the briefs added up to more than 2,000 pages. The client trusted his solicitor implicitly and took Khaitan with him from Calcutta to Bombay to wait on Bhulabhai Desai to hold conferences with him. They all went a full month before the suit was to be placed on board for hearing. But Bhulabhai, who was one of the busiest lawyers in his time, was far too busy from day to day in other matters. He could not afford to give Khaitan and his client more than half an hour each evening. Even at these conferences, he had to be constantly reminded of the facts, made to read and reread the case papers. At the end of 3 weeks, P. Khaitan was so exasperated that he told his clients, "My dear fellow, the case is tomorrow. We have done all we can, but fate is against you. Your council has not read your brief, and all you can do is to go to the Mahalakshmi temple and pray that some miracle happens. Fortunately for the client, the miracle did happen. Next day, when the case reached hearing, Bhulabhai Desai stood up without a note, without referring to any part of the 2,000-page brief lying before him. He gave the judge a masterly summary of facts, proceeded to deal with the law for the entire morning session. Khaitan, one of Calcutta's most experienced solicitors of his time, told A.K. Sen that it was a consummate performance, one that he had never witnessed before. Of course, not everyone can emulate Bhulabhai, the great Bhulabhai Desai, but you must try. Incidentally, Motilal Setalvad, India's first Attorney General from 50 to 63, he was in the 1930s a junior of Bhulabhai Desai, and he has written a biography of his senior. If you can, try to read it. It is in the series of Builders of Modern India, published by the Publication Division of the Ministry of Information and Broadcasting, Government of India. It contains a very enlightening chapter, particularly on the INA trial, and it is worth a read. It's because it's a fascinating account of Subhash Chandra Bose, Indian National Army during World War II, where, as Setalvad writes, though there were 17 advocates in the courtroom who were assisting him, including Jawaharlal Nehru, that is Panditji, wearing a barrister's gown which he had not donned for 30 years. The lead counsel for the defense was Bhulabhai, and as Setalvad writes, whose brilliant, searching advocacy and cross-examination rang a bell throughout India. Another great advocate of the 20th century was Nani Palkhiwala in the post-constitution period. He is hardly remembered today in the hurly-burly of current-day lawyering and politicking. It is high time we remember him. In his time, he was able to convincingly argue and win the three greatest constitutional cases of modern times. One, Golaknath in 1967, before a bench of 11 judges. I had the good fortune to be briefed as a junior, assisting both Ashok Sen as well as Nani Palkhiwala. Second, Keshavananda in 1973, before a bench of 13 judges. But I had then shifted to from Bombay and was Additional Solicitor General of India in Delhi. And because of conflict of interest, having appeared for the petitioners in Golaknath, I could not appear for the Union of India. And third, Minerva Mills in 1980 was before a bench of 5 judges, in which my son Rohington usefully assisted Nani Palkhiwala and gained for himself recognition as a competent young advocate of the Supreme Court of India. The last case was particularly notable because it consolidated the doctrine of basic structure, now a famous doctrine, and also because the judge who delivered the judgment in that case did so dutifully following the narrow majority view in Keshav Ananda, which was 7-6. Even though the judge who delivered the verdict in Minerva Mills, Justice Y.V. Chandrachud, had propounded the minority view in Keshav Ananda, and the minority view was there was no basic feature in the Constitution which was unamendable. I always give Chief Justice Y.V. Chandrachud full marks for his acute sense of judicial discipline, of dutifully following precedent. But I must also let you into a secret. I have never known anyone, no one, neither judge nor lawyer, ever poking fun at Nani Palkhiwala's arguments, except once. This was dared by another great lawyer, Kanyalal Mishra, who did so quite defiantly in Golaknath's case. I was also appearing with Nani in Golaknath, and K.L. Mishra was appearing as Advocate General for his state, the state of UP. Now, in his argument before the bench of 11 judges in Golaknath, it was Palkhiwala who had first advocated the theory of implied limitations in the Constitution. Palkhiwala relied upon the relevant part of Article 368, which said that a bill to amend the Constitution shall be presented to the President, who shall give his assent to the bill. And thereupon the Constitution shall stand amended in accordance with the terms of the bill. This must mean, Palkhiwala argued, that at the end of the procedure for amendment, the Constitution must stand. That is, it must remain. Therefore, a wholesale amendment repealing the provisions of the Constitution was unacceptable, unthinkable. Hence, implied limitations had to be read in Article 368. That was his argument. Palkhiwala kept emphasizing the words shall stand amended in 368, not once, but several times, in words and in gestures, as was customary with him. When he was agitated, he used both his hands to emphasize the point. When Kanhaiyalal Mishra got up to reply, he made his submissions in low key. He submitted there were no implied limitations to the amending power. Unlike his opponent, Palkhiwala, he was not agitated. After he stated his point, he poked fun at Palkhiwala's emphasis on the words, shall stand amended. What should it have said, my lords, he asked, in mock surprise. Should the clause have said, the Constitution shall sit amended? He then went on, no, my lords, plain English cannot be subverted to suit any particular point of view. Now, Kanhaiyalal Mishra's English, this is very important for you to know, was impeccable. One could outsmart him, sometimes on law, but never on the English language. In his young days, in 1926, he had sat for his ICS, Indian Civil Service Examination. And in the paper on English essay, he had scored 150 out of 150. But he was rejected as a candidate for the Indian Civil Service. This was only because in his young days, Kanhaiyalal had committed the unpardonable sin. He had joined the Indian nationalist movement and the British had a black mark against his name. His scoring 10% marks in the English paper had a sequel. It was Sir Arthur Quiller Couch, the well-known professor and master of the English language, also one of the editors of the Oxford Book of Verse, who examined and marked Kanhaiyalal's paper. He was so impressed that he not only gave him full marks, but took the trouble. This is very important. Just see the manner in which he did it. He took the trouble of writing a personal letter to Kanhaiyalal's professor in Allahabad University. But in it, he summarized K.L. Mishra's brilliance in one eloquent but devastating sentence. And I quote it to you. It was the Englishman who conquered India, but it was only Kanhaiyalal who has conquered English. That was his. So let this be a lesson to you all. I say this once again, on the proficiency, need for being proficient in English is very essential if you are to become a good advocate. The draft Constitution of India was prepared in English. After nearly 3 years of debate in India's Constituent Assembly, it was finalized in English, adopted in English. The concepts of liberty, equality, justice are all in English. They are concepts familiar to Anglo-Saxon and common law jurisprudence and not to civil law jurisprudence. One of the only two languages of India are and remains English. So if you are keen to be an advocate, practicing in India and hopefully and ultimately establishing yourself in one of the high courts, ultimately in the Supreme Court, you must know the English language, and to know it, you must know its literature. Another advocate of the 20th century was Sir Dinshaw Mullah. He was better known as one of India's great jurists, perhaps the most prolific. There is a story about him that was told to my wife by his granddaughter, and my wife and his granddaughter were very friendly. And the story goes like this. Mullah had passed his bar examination, and after returning to India, he was wondering whether he should join the profession of law or pursue his life's passion, which was poetry. Mullah fancied himself as some sort of a budding poet. In those days, the only form of communication between India and England was by letter that traveled by sea mail from India to England and back. Mullah sat down and wrote to Lord Alfred Tennyson, the poet laureate of England. He never knew him, but he wrote just the same. He sent the great English poet some of his own poems, earnestly inquiring whether he should take up his career in the law or whether he should stick to poetry. Tennyson, seeing a letter from some forlorn student in faraway India, just like Frankfurter in the year 1954, promptly picked up his pen and paper and wrote in his own hand, "Dear Mr. Mullah, I thank you for your letter and your poems. I have read them, but I think you should stick to the law." Providential for Mullah that Tennyson wrote back. Just imagine if Tennyson had not written back to Mullah and Mullah had embarked on his urge to write poetry, abandoning the legal profession, the entire jurisprudence of modern India would have been the poorer. Mullah was a great jurist, ending up as a privy councillor, but not a very good advocate in his time. K.L. Mishra, however, was one of the most powerful advocates of his time and one of the most persuasive. It is recorded that the 14th Chief Justice of the US Supreme Court, Earl Warren, told Kanhaiya Mishra after meeting him and hearing him speak at Varanasi, that Banaras that is, that if they had a counsel like him back home in the United States, he as Chief Justice would waive the time limit to hear such counsel. Great tribute to a great advocate by a great judge. I had the privilege of listening to him arguing a criminal appeal in the Bombay High Court when he was there for about a month in the 1960s. He treated the court with utmost respect and courtesy, which was reciprocated by the bench. He did not succeed in the case. He lost. The judges kept questioning him, questions which he coolly and politely answered. He knew, like what all great advocates know and must know, that to lose your temper at a judge is losing half the battle in court. If you have a temper and get upset at what the judge sometimes says, control your temper. And if your temper is uncontrollable, find some excuse to get angry with your junior sitting next to you. This is one of the tricks of the trade. The judge will come to the rescue of your junior because he will think you are unnecessarily losing your temper on a young man who is trying to assist you. Kanhaiya knew the tricks of the trade. Remember that expression tricks of the trade is not a disparaging remark. It is a mark of appreciation for a person steeped in the fine art of advocacy, which after all is the art of gently persuading the judge to your point of view. Lessons on advocacy are often imbibed from the great and successful. If you read Quinton Hogg, that's Lord Hailsham's biography, you'll find he writes about the very useful lesson on advocacy that he had when he was a totally inexperienced pupil at the bar. And he learned this from Sir Wilfrid Green, who was then Master of the Rolls, his senior. Quinton Hogg, that is later Lord Hailsham, was sitting next to him one night at a dinner when Wilfrid Green suddenly asked him a question. Green says, suppose you were instructed in a case where you had 2 points to argue, both of them bad, one worse than the other. Which would you argue first? So Hailsham writes, he was a young lawyer, I suppose I would argue the less bad of the two. Wrong, Green says, wrong. You must argue the worst point. Put your very best work into your worst point. Eventually, the judges will drive you into a corner and you will have to admit defeat. And you will then say, my lords, there is another point I am instructed to argue. I am not quite sure how to put it. And you will then put it, the better of the two arguments, but not quite as well as it should be put. And after a little while, one of the old gentlemen on the bench will interrupt you. He will say, but surely, Mr. Green, you might put it in this way. and he will put it exactly as you really ought to have put it in the first place. And then, but only then, you will be at least halfway to winning your case. What a beautiful example. It is an illusion to think that great cases are won or lost because of their inherent strength or weakness. Advocacy, always remember, advocacy plays a vital role simply because the judge is also human, like the advocate. The only difference is he or she is trained to control emotions better. So thank you all. After this very long spell, I wish you all the best of luck in becoming an advocate.